submissions to Magistrate Sharon Cure pertaining to why she should recuse herself as the magistrate presiding over Thompson vs. Lane. 1. Failure to ensure procedural fairness. Dr. Lane was not provided with evidence in possession of the prosecution prior to the hearing. This includes a lengthy prosecution file, video evidence, and copies of the search warrant that the complainant issued. In contrast, Dr. Lane was asked to provide the prosecution with copies of his evidence, in the form of video and still images, prior to the presentation at the hearing scheduled for the 27th of November 2018. The magistrate tasked the prosecution with formatting Dr. Lane's video evidence, which presents a clear conflict of interest. Dr. Lane did not get to format the prosecution's evidence. Dr. Lane was severely limited in asking the witness Sharon Thompson questions about the search warrant, while the prosecution was freely allowed to pursue this line of questioning. The prosecution was allowed to ask Sharon Thompson about the content of the search warrant, which she answered, while Dr. Lane was not allowed to even see a copy of the search warrant, the contents of which Sharon Thompson described in open court. Dr. Lane was, in a sinister manner, portrayed in open court as a drug-making suspect with this line of questioning. The magistrate would go on to question what Dr. Lane was using the chemistry equipment for, debasing the magistrate's own claim that Dr. Lane could not talk about the search or the warrant on the grounds of relevance. Dr. Lane summoned 5 police witnesses to court given there was evidence that they could be holding exculpatory evidence. The magistrate did not ensure these witnesses appeared in court, and did not even address the issue of why only 4 of the 5 provided statutory declarations to excuse their absence. The magistrate read out loud to the court evidence, including false evidence, provided by and she formally received that evidence, but Dr. Lane did not get the opportunity to cross-examine. Dr. Lane did not get the opportunity to cross-examine anybody from Tasmania Police, the prosecuting entity. The magistrate allowed the prosecution to openly discuss the contents of the search warrant application to smear Dr. Lane, but Dr. Lane was not permitted by the magistrate to view the search warrant material himself, despite the fact that Dr. Lane explicitly requested it. The magistrate explicitly restricted Dr. Lane's questioning of Sharon Thompson, the complainant, because the magistrate was confused about how to handle a situation where the respondent to a restraint order needed to directly question the complainant. The right for the respondent to directly cross-examine their complainant is enshrined in law, and the magistrate was wrong to hinder Dr. Lane's questioning. The magistrate openly provided advice to the prosecution on how to prosecute Dr. Lane, and how to prevent Dr. Lane from showing evidence in court. The magistrate openly encouraged the prosecution to claim that Dr. Lane stalked the complainant by reading her Facebook posts. The magistrate openly suggested to the prosecution that the prosecution claimed Dr. Lane's attempts to summon witnesses amounted to a fishing expedition. The prosecution then did just that. The magistrate would then go on to block Dr. Lane's attempts on the exact same grounds that she had suggested to the prosecution. 2. Apprehension of bias. The evidence of bias against Dr. Lane, and in favor of the prosecution, is evidenced by the appalling lack of procedural fairness. And in addition, the magistrate effectively set conditions in the hearing whereby the only relevant contribution was the testimony of Sharon Thompson herself, taken at face value, despite Dr. Lane having proof that Sharon Thompson had lied even under oath, and that Sharon Thompson had a history of being an overreactionary pro-prosecution zealot. Anything Dr. Lane said was a complete waste of time, being undermined, ignored or dismissed. The magistrate led the witnesses Thompson and at least 3 times, in order to direct the narratives in a way that disfavored Dr. Lane and favored the prosecution. The magistrate did this by interjecting with suggestive directions before the witnesses could answer Dr. Lane's questions. The magistrate would repeatedly fail to acknowledge the argument Dr. Lane made about the relevance of the evidence for the placement of a listening device that would have recorded his phone call with Sharon Thompson, a phone call that the magistrate would go on to raise several times. The magistrate would simply change the subject and not address Dr. Lane's argument. The magistrate applied arguments against Dr. Lane that were so daft, they could only have been conceived of on a foundation of rank bias. This included the suggestion that reading someone's public Facebook posts was stalking, and that looking up someone's contact details on the internet in order to contact them was stalking. As if someone can even be contacted without first looking up the contact details. The magistrate sought to undermine, even dismiss, the relevance of Sharon Thompson's use of Facebook. Yet the magistrate sought to emphasize the importance of Dr. Lane's use of Facebook, and the magistrate even suggested that the prosecution use it against him. The magistrate mocked Dr. Lane, and even blatantly mimicked him at one point in the hearing, and insisted on asking questions about his education as if Dr. Lane might be using a fake title. The magistrate cast doubt on the veracity of evidence Dr. Lane presented in the form of still image printouts, yet insisted that other still images be printed out themselves. The magistrate showed she had a preconceived acceptance, without any skepticism, of the prosecution's evidence, while Dr. Lane's evidence was either not allowed to be presented, or its veracity undermined. For example, the magistrate referred to the complainant's alleged fear as being fact, when it hadn't been proven at all. Dr. Lane's exposure, by cross-examination, of the complainant's conspicuous lack of something to be frightened of was shut down by the magistrate.